Your Honor, it was such a pleasure having you as our keynote presenter today at our conference here in San Diego. Thank you so much for participating.
Thank you, Brian, for inviting me because I truly enjoyed it. I've known a number of your members over the years, and part of the enjoyment of coming back and doing these things is getting to see people again and refreshing friendships. So it's wonderful to be here. Thank you.
Well, it was a fascinating presentation in how particularly you're trailblazing into a new area with litigation and trying to resolve these matters in the tax court. Hot tubbing, I like the story you told when the first time you did it, and the young lady, I think it was an attorney, busted out into the hallway and was like, Judge Laro wants to do some hot tubbing.
Exactly right.
Tell us about how that came to be. From what I gathered from your presentation, you had studied a case in Australia and were very curious about it. Tell us about that part of your discovery of this technique.
Well, I think it all started with my dissatisfaction with the present system. Which has its virtues but some severe limitations as well. And one of the concerns about the present system is that it tends to attack credibility. It tends to use on cross-examination sort of a gotcha type of mentality. And at the end of the trial, the judge is then left with a record that's somewhat in disarray, and yet you have to try to find the truth of the matter from that record. So I was searching around for something to improve that, and I was introduced to this system that began in Australia, and from there I just took the concept and then improvised it in a case that I was doing in the New York area. And so I'm probably doing what people in Australia did, but I'm doing it differently. And I've improvised and I have modified it so that it suits my needs in a judicial environment, I think, better than the one I saw in Australia. So that's what happened.
Mm-hmm. Yeah. So for our members who may not have seen the presentation this morning, can you just briefly or rather discuss a bit about the concept behind hot tubbing? It's quite a new trend, or rather a new process. So just talk about a little bit about what's involved.
It is, Brian. What it is that in a traditional case, lawyers will examine witnesses, expert witnesses, by doing direct examination and then doing cross-examination. And as they say in that process, lawyers try to basically destroy the credibility of the witness, and the experts never really get a chance to express themselves. They're just answering select questions that are designed to make them look bad, frankly. Hot tubbing is a different environment. Hot tubbing is where the judge leaves the bench and goes down into the middle of the courtroom, sits at a table like the one you and I are sitting at right now, and the experts and the judge will engage in a conversation. The lawyers are not at the table. The lawyers are flanking the table in the sense that they are in the perimeter, and they are permitted, under my rules, they are permitted to object if they find something objectionable. But in all the cases in which I've done that, they've never objected. So what transpires is that I then say to the experts, let's have a conversation. And let's talk about a select number of issues that pertain to the valuation and how you've arrived at what you've done, and the differences between yourselves. And everything begins where people look at me and they start to engage me. And I try to discourage that by saying, talk to each other. Right. And I, if I'm successful, I become a listener. And what happens is that they then begin to talk to one another, not as adversaries, but as professionals, such as they would do at a NACVA meeting, where you sit down over lunch and talk about an issue that is of common interest. And so they will talk about it, and they say how they arrived at what they did, and what their assumptions were, and their techniques, and then they would talk about what their strengths and their weaknesses were, and they would play on one another, and by so doing they would add light to their actions. And so what they did was illuminated, and it became more transparent. And in a few cases, not in every case, but in a few cases that I've done this, Brian, the witnesses have actually made modifications to their testimony based on those discussions. And the real virtue that I see that comes from this is what I mentioned this morning, and that is that when it was all over, I would say to them, well, do you think this has been, this hot tubbing thing, and do you think it's been of any value to you? And inevitably I get the same reply, which is that it's the first time that these experts have ever been allowed to have a discussion with one another about these critical issues.
Right.
And to be able to express themselves as opposed to try to answer a few select questions that are designed to trip them up.
Kind of gotcha questions.
Exactly.
Yeah. Another topic you discussed, you and Mel, who you co-presented with, were some of the myths about the hot tubbing experience, in that the attorney's role in the process will be minimized, or that it creates more work for the triers of fact. I mean, you and Mel went through several key myths about this process. Talk a little bit about some of those.
Okay. Sometimes the attorneys worry about this technique because they like to control their environment. And that's the way they're trained, and I respect that. But I believe that that adversarial method has its limitations and has its usefulness. And so I don't want to take away from the attorneys their right to do what they've been trained to do.
Sure.
So I use hot tubbing as an add-on as opposed to a replacement. I believe that some judges look upon it as replacing traditional cross and direct testimony. I don't do that. So I let the attorneys do their thing, and in that manner they can leave the courtroom at the end of the day feeling that they've been well paid for their job and they've done a good job. By the same token, I get a lot of, I would say, merit out of the add-on element, which is the hot tubbing. So that's that. From the point of view of the judge, it is a little more work for the judge. Because in order for, when I have to tell you that when a judge sits up on the bench and the trial goes on, the judge could be paying attention or the judge could be daydreaming. I mean,
Right.
You have no way of knowing.
Right.
And so it becomes a little bit of what I'll call a relaxing environment for the judge, which is fine, which is fine. I'm not critical of that at all. But what I am saying is that when the judge participates in the hot tubbing, it's like you're engaged in a conversation. So you need to be well informed. You need to be able to ask key questions. You need to be able to moderate if it's necessary. And that is its virtue, and that is that at the end of the day, the judge has to take the record of the case and decide what the truth of the matter is, and ultimately who wins and loses. The judge will find that in every case, there are always gaps of information. And so the judge will fall back and say, gee, if the attorneys had just asked these questions, I would have been more informed and I could have made a better decision, okay? But the record closes and that's the end of that.
Right.
Hot tubbing gives the judge an opportunity to sit and say, let's talk about these issues, 1, 2, 3, 4, 5, which are important to the judge in deciding of the case. So it brings out a discussion on the key things, which often the attorneys do, and sometimes the attorneys miss as well. So that's what that's all about.
How do you feel if this trend picks up more steam and more judges are open to using this technique or this process? How do you think that will benefit the legal system overall?
Immensely, I think. Of a couple of judges other than myself who have done it, and they've asked me to explain it to them before they did it, one of the judges said to me, "This is perfect. I've been looking for an opportunity to do this kind of a technique. And so that judge was very much enthused by the process. The second judge also said, very interesting, this is another opportunity for me to become, I would say, more of an important role player in the decide. Other than sitting there passively, sure. It gives the judge an opportunity to really ask the right questions and participate in the discussion. So I think in time, Brian, the judges who like to be active in their cases, who like to ask questions, who like to take an active interest in the trial, I think will be enthused by this process. To the judges who feel that they view themselves as being more traditionalists and just sitting back and listening, right. They may never do it. Right. And that's up to them.
Yeah.
Yeah.
Well, you certainly have had a great impact on the profession from your involvement with some amazing cases over your career. How did you find your way into wanting to, I know you initially were a trial attorney, how did you find your way, and what was that spark that led you on the path to be where you are now?
You know, it wasn't a direct path.
Okay.
So what happened is that I got out of law school, mm-hmm. and I said I did want to become a trial attorney, mm-hmm. because I didn't know much about being a lawyer, and being a trial attorney was sort of what the public kind of knew, and therefore I identified with it, and I liked trial law. Okay. So I did that, but it wasn't tax law. It was just trial law, and I did that for a few years until one time I was in a law firm, and one of the partners for the firm said that he wanted me to assist him with some tax-related matters. And I had taken tax in law school, mm-hmm. but I didn't feel all that sharp on it, so I went back to school at night and took some tax courses at a nearby law school and realized how much I really enjoyed that. So then I left the practice of law. Okay. And I went to NYU full-time as a graduate tax student in tax. Mm-hmm. And then got a master's of laws in tax, and then went back into the practice and then became a tax attorney. And in the course of being a tax attorney, I did some work before the United States Tax Court. Okay. I wasn't there often, but I did do some trials. Mm-hmm. And it's exciting, and it was fun.
Yeah.
So.
What advice or what suggestions or advice would you give to evaluators? We had a question from the audience today that was very similar. If they want to prepare for court or for trial as an expert, what are some of the key things from your perspective would help them be prepared and help them be more effective in their roles?
Well, the first thing is that they should do a lot of reading. I made a little fun on that this morning by saying they ought to read my book, but right. But they ought to do a lot of reading, and they ought to read up on the federal rules of evidence and see what it means to be an expert witness. Mm-hmm. They ought to read the tax court rules if they're going to be in tax court, and see what it means to be an expert. Mm-hmm. They ought to become totally familiar with the subject that they're about to render an opinion with. Sure. And so they ought to be broadly read and so forth. And they should do a lot of thinking. When you're out in practice, you don't have as much time to sit and think, but they ought to do a lot of thinking about the subject matter. Mm-hmm. And then they ought to think about ways in which they can take this very complex subject of valuation and ways in which they can then explain it to somebody who doesn't understand it. Okay. And I think one of the ways to do that is to imagine that you're talking to, no disrespect, but imagine that you're talking to a high school student who's smart but not totally knowledgeable and informed, sure. And try to explain a very, very complex subject to a high school student so that the high school student knows what it is you're trying to say. And then get somebody to ask you questions and see how well you do in answering them, and whether you're informed and knowledgeable, and whether you're clear and coherent. And then also, and this is most important, don't be afraid to admit that you don't know something.
Sure.
And so if a question is asked of you and you don't have an answer for that, I would say just that. I don't have an answer for that. I don't know that. If you've made a mistake in the course of what you're doing, then you need to say, I've made a mistake.
Right.
In other words, what the court expects from an expert witness is complete intellectual honesty and candor.
Okay.
And so those are things sometimes people have innately, and sometimes you have to train for them.
Right.
And so that's what I would do.
Great advice. Thank you very much.
Thank you.
And thank you for spending a little more time with us to learn more about this hot tubbing opportunity, but also a little bit more about you as well. And appreciate all of the contributions you've made to this profession. And again, we appreciate you being at our conference as well.
Thank you for inviting me.
Thank you so much.
Okay. My pleasure.